much. Welcome back. We are going to get started with our afternoon program. My name is Hannah Johnston. I teach at York University in the School of Human Resource Management, where specifically I teach industrial relations. And our next presenter will be Six Silberman. Six is a postdoctoral researcher at the Bonavero Institute of Human Rights at the University of Oxford, working with Jeremias Prassel and colleagues on research on the regulation of algorithmic management. Silberman is also a consultant on digitalization for the International Trade Union Confederation and has previously worked as a trade union official and a software engineer. So Six is joining us remotely, and Six, you're up on screen there, and we'll be sharing some work that they've done in conjunction with Jeremias and some other colleagues as well. And so with that, Six, I pass it to you.
Thank you, Hannah. Thanks to everyone. I am not Jeremias.
Just give us a moment. We need to increase the volume significantly. Six, can you do an audio again?
Hello, hello. How are we doing? Are we doing better? Audio is working.
And if you can project your voice or raise levels on your end,
Okay, I'm moving my face closer to the microphone.
Hi, Six. It's likely your headset. Do you know if you can increase levels on your headset? You're just coming in very quiet.
I'm not using my headset. I've got a wired set of headphones, which is plugged into my speaker jack, and I believe I'm using the built-in microphone on my computer.
Okay.
Oh, noise removal, original sound. Is that better?
No. I think it's a little bit worse.
No, it's worse. Great. Okay. Here's what we'll do. Let me try using the non-wired setup. That might be better.
Thank you.
All right, we're gonna try
this. Is that any better?
Yes, that's much better. Thank you.
Phenomenal. Okay, great. Now that we've gotten that part out of the way, there's always a sort of object lesson in technology when we talk about technology. I will start now. Are we ready? Interpreters can hear sound. Everything is working.
Get a thumbs up from the audience. Everybody ready? Buckle up. Here we go. All right, Six.
All right. Well, I'll just share my screen. So this talk is about regulating algorithmic management. It is based on work done by a team here at the University of Oxford. This is not a background. This is actually Jeremias' office. It really looks like this. The work was funded by the European Research Council. That's why we have the little ERC logo and the little flag. This is the main paper. You do not have to read this paper. I will tell you what is in it, and then you can decide later if you want to read it. This is the team. I am not Jeremias Adams Prassel, but I will do my best to convey this work in a manner which would represent the whole team. So let's get immediately into it. How can algorithmic management be regulated? Well, as with many things, you need a regulatory framework. What should that framework do? We argue that it should do 9 things. First, it should prohibit some things. And specifically, it should prohibit egregious or patently inappropriate data collection and processing practices. For example, it should prohibit employers using data about you to predict whether you are going to join a union or go on strike, or have a child, or apply for a job with a competitor. Those things should be unlawful. Second, it should establish the acceptable legal grounds or legal bases for employer processing of worker data. For those of you who are unfamiliar with the delightful obscurities of European data protection law, a legal basis is a somewhat abstract answer to the question, why is the organization collecting or processing this data? So in this case, the organization is typically going to be the employer, and the processing might be necessary for establishing the contract of employment, for example, or it might be necessary for complying with an external legal obligation. But the regulatory framework should establish what legal bases, what answers to this question, why is the organization collecting or processing this data, are acceptable and what kinds of answers are not acceptable. And there are some answers, some legal bases, which might be acceptable in a consumer context or consumer relationship, but which are less appropriate and potentially entirely unacceptable in a work context. Third, the framework should establish that the organization doing the data collection or processing, again, probably the employer, but possibly a technology vendor or provider who's been contracted to do data processing, must notify the individual concerned, in this case, probably the worker. And this individual should be notified about what data are being collected or generated, how they're being processed, and for what purpose or purposes, and what rights they have with respect to that data and that processing. So far, relatively uncontroversial. Now we get into new territory. The framework should establish that the employer must notify workers' representatives about the processing of worker data. And the framework should establish that those representatives have the right to access those data. Here we get into questions of, does the union have the workers' consent? And I would say, yes, there should be a procedure which allows individuals to consent or object to access and processing by the workers' representatives. In Europe, that would be the Works Council, perhaps, or the trade union. The framework should also establish that worker representatives have the right to initiate legal proceedings or file complaints if a complaint that's not a legal proceeding is part of data protection enforcement in the jurisdiction in question on behalf of individual workers regarding employer processing of their data. So a representative right in formal processes. Fifth, the framework should prohibit full automation of some decisions. There's a question here about which decisions should require substantive or meaningful human involvement, and we have argued that at the absolute least, automated determination of the employment relationship must be prohibited. It could also well be argued that disciplinary decisions or other evaluations or decisions with adverse consequences for workers should also require substantive or meaningful human involvement. I personally would argue that. It should establish a right for affected workers to request human review of fully or partially automated decisions. In the paper, we call this human after the loop. The loop is the decision. I don't love this terminology. Human in the loop is the sort of typical policy world jargon for, oh, there's a human involved in the decision-making process. I don't think we necessarily love this terminology, but it's become sort of popular. So we went with the loop as this kind of metaphor, and now we're going to put humans in various positions around the loop, as you will see. I think it's a useful conceptual device, but it can be a little confusing. The framework should establish that employers must consult with worker representatives before introducing or changing data processing or automated decision-making systems in ways that are expected or reasonably likely to affect working conditions. So in the European context, we're familiar with this phrase, information and consultation. What does this mean outside of the European industrial relation context? This means worker representatives should have a veto. That's what I think we're saying here. And I think it's fair. It's not too strong, I don't think, to say, yeah, worker representatives should be able to say, no, we don't want this, and that should be legally binding. And in the paper, we call this humans before the loop. Hopefully, that's the loop metaphor is starting to make some sense. Eighth, the framework should obligate employers to conduct regular assessments of the impacts on working conditions of their data processing and automated decision-making systems. Worker representatives must be consulted during the assessment process. The written output of the assessment should be made public, and there should be a space for the views of workers and worker representatives in the written publication. I'm sure you're wondering where, in respect to the loop, we're putting this. This is humans above the loop. And this is not quite set out in the paper as a separate requirement, but I've added it here. All these humans have to be formally, legally protected from retaliation and other adverse consequences for performing these functions. And we know, for example, in the European data protection context, the framework creates this role, the data protection officer, and we've seen some situations in which there's sort of concern about management inappropriately pressuring the data protection officer to take certain decisions or reveal certain information to management. And obviously, if the data protection officer feels that they can't say no to these kinds of requests because they think that they might be fired, then you have a problem. So that's kind of what that's about. So those are the headlines. You might have some questions about all of this. We'll have a fair amount of time, I think, for discussion, but in the next 15 to 20 minutes, I'll try to answer somewhat preemptively some questions I think you might have. And I'll try to address 4 main questions. So first, what about artificial intelligence? How do these proposals relate to artificial intelligence? What are we really talking about when we talk about algorithmic management? Is this the same thing as AI in the workplace? What's the difference if there's a difference? Second, why are we proposing these provisions? What is the idea behind them? Did we just make them up? No, we didn't. Third, is this too much, right? There's a sort of where we are enduring at the moment a rather deregulatory, to use the technical Californian term, vibe in a lot of jurisdictions. Is this over-regulatory? What would we say to the allegation that we've heard, for example, from Mario Draghi in the European context, that this is too much red tape, data protection law is killing European small business? You know, if that's what's happening in Europe, how do we think about that in other jurisdictions? And then finally, okay, now what, right? So here's this nice academic paper. Can you use it for anything? It's all written in EU speak. Can you use this in Canada? What's happening internationally at global level? What now? So I'll start with AI. What is the relationship between these two terms, and what is the difference? Obviously, there's a lot to be concerned about with respect to AI and work. And I'll try to answer this question. You know, which of these concerns do these proposals address, and which ones do they not address? And I'm going to try to sketch an answer to that question by defining terms. So I'll start with this term algorithm. When we talk about algorithmic management, we kind of slide by this term algorithm as if we all know what we're talking about, but this may not always be the case. So other people may have other definitions. This is one I find to be reasonable. And here we say, what do we mean by algorithm? We mean a sequence of rules or a procedure for doing a task. And what does that mean? If I say for doing a task, I'm implying that I kind of know what the task is. If I just have a sequence of rules and there's no purpose or task associated with it, that may be a procedure, but it may not be an algorithm. So, for example, an algorithm for computing 9% sales tax on a price of purchase might be multiply the price by 0.09. That's an algorithm with one step. We also have algorithms for calculating routes. If you used an app on your phone to tell you how to get somewhere today, maybe to the event venue, it used an algorithm to calculate the route. And if you take computer science in the university, you'll learn some of those algorithms. If you learned about this event through your email software almost certainly used an algorithm to decide that that email probably was not spam and should not go into your spam folder. As of course we all know, sometimes the algorithm makes wrong decisions and puts emails that are not spam into the spam folder. So that's a property of algorithms, which is quite important, as it turns out. Sometimes they're wrong. But overall, I think we can say this: an algorithm is like a recipe. So what about algorithmic management? Algorithmic management, I will say, is the use of algorithms, procedures, or recipes in management tasks that previously were done by human managers using typically less formalized human judgment. So these are tasks like hiring, assigning work to workers, evaluating worker performance, deciding who's going to get promoted, disciplining workers, and making decisions to terminate employment contracts, dismissal. So that's what I mean when I use this term. What about artificial intelligence? This is more difficult because historically, this is a marketing term. It's not a technical term. It is not well defined, and in fact, it has never been well defined. It was, in fact, always a marketing term. It was invented in 1955, and if you've never heard this story before, I encourage you to go look up the history of this term. It's in the Wikipedia entry. It's not hard to find. It was invented in 1955 as part of a funding application for a research workshop. It was like a summer 6-week research workshop or something. And it was just a marketing exercise. They were like, oh, well, the funders will go for this. So I'm sure we can all relate to that. And then, of course, it sort of went viral. And now it's used basically, I think it's fair to say, to refer to 3 categories of software. First, most recently, these so-called generative AI systems that we are all either using or studiously not using in the last few years. Second, the previous generation of machine learning systems. You might have an app on your phone, for example, that you can like hold up really annoyingly in a restaurant and it'll tell you what song is playing. You might have an app that can translate text between French and English. These are often called AI, but technically they work differently from the new generation of generative AI technologies. They use a previous generation of technology, and really they're simpler and they require less hardware and less computation usually. And it's also, I find somewhat challengingly, used in policy debates increasingly to mean any complicated software. So right, if you read the definition of artificial intelligence in various policy instruments, I won't name any names, but it's hard to draw a boundary around this term. And sometimes this is not a problem. Sometimes that's fine. But if we are writing legal definitions in legislative instruments or in collective bargaining agreements, we might want to be careful about this, because if the applicability of a set of rights hinges on whether or not a particular system is AI, then we can find ourselves having a lot of debates about our definition of AI. And to some extent, this can just be avoided by using broader terms like data processing. So that's my first pass at answering this question. What about AI? What does all of this have to do with AI? These provisions that we've proposed do not directly address issues around the use of generative AI to do work. Obviously, intellectual property questions are extremely salient here, but I think they do create a framework for bargaining because, for example, if management shows up at work one day and says, hey, everyone, we're using this chatbot to make our work 10 times faster now, everyone has to do this. That affects working conditions, and that would, within this framework, then require consultation with worker representatives. And of course, the moment that management starts to use generative AI to manage work, for example, something I saw to my great horror in a coffee shop in London 3 days ago, I saw a person interacting with ChatGPT and asking ChatGPT to draft an employee performance evaluation. And I wasn't surfing over their shoulder like that creepily, because they had asked ChatGPT to format it in such a way that the text was enormous. And I could see the name of the employee who was being evaluated from across the coffee shop. And I was like, oh, look at this. I'm going to have some sort of nervous break watching this happen. But this person had decided that this manager had decided that they were not going to bother to write an evaluation. They were just going to have ChatGPT do it. And, within this framework, we're now talking about algorithmic management, and all the provisions would apply directly. The worker representatives would be able to intervene here and say, if you want to do it this way, this is what needs to happen, or no, we're not going to accept this. So we're about halfway through now. I've been rambling for about 15 minutes. Why don't we just pause for a second? Let's all stand up. I'll stand up. I don't know if you can see me, but I'm going to stand up. We'll all stand up just for like 30 seconds. We're all humans. We're not robots. We need to move around sometimes. We can't just ingest information continuously. Just for 30 seconds.
You can't see the room, but we've had excellent participation.
I'm so glad. Thank you for that information. Okay. We stop that now. Stop being human. Stop being human, please. We'll continue. Okay. So why are we addressing these provisions? What's the idea? They're designed to address 3 risks that arise from the use of algorithmic management in organizations, and I will list them fairly quickly. First is privacy harms. If my employer is counting my keystrokes, taking screenshots of my computer screen, taking videos of my house through my camera while I'm working from home, for the arguably reasonable sounding purpose of ensuring that I'm working while they're paying me, that's a reasonable sounding purpose, but it's still a privacy harm. There's no actually legitimate justification for all of that collection of data. And we argue, based on the evidence, based on the psychological research, based on what we know about what is good for people in the workplace, no, that's a harm and it should be unlawful. If my employer buys data about my purchasing behavior from a third party, and as a result knows that I have a medical condition that I have not disclosed to them, that is, again, in itself a harm, a privacy harm. And that's enough reason in our analysis that it should be unlawful. So these provisions aim to address these kinds of harmful situations, mainly by simply prohibiting them. Second, widening information asymmetries. Employers already know, quite often, more about workers than workers know about their employers or their individual managers. And what does this do? Of course, this gives employers more bargaining power. The widening asymmetry of information that digital technologies makes possible can further widen the already existing imbalance of bargaining power. So if my boss knows what I was talking about with a colleague in the break room when the boss was not there, because there's recording technology all over the factory, or knows that I'm planning to have a child because they've bought my purchasing history from a third-party data broker, or knows that I've been updating my LinkedIn profile because they're surveilling my social media activity, all of this knowledge opens up a lot of interesting levers for my employer to use to get me to do things that I may not otherwise be amenable to doing. What does this then do from a trade union point of view? Well, this granular, pervasive, individualized data collection, which is often required by sophisticated algorithmic management systems, gives an employer information about individual employees. This allows them to create incentives for individual employees to bargain individually rather than collectively. So detailed, individualized data collection under algorithmic management can erode the conditions for collective bargaining. Third, loss of human agency. What are we talking about here? When decisions are made algorithmic, people don't make them anymore. They're made automatically by the system, right? So who are we talking about? Mostly we're talking about middle managers. We're talking about the agency of middle managers who make decisions about work allocation, performance, and discipline. If I'm 10 minutes late to work because my kid was sick, I can tell my manager knows me, my manager knows that I wasn't just being a flake. They know that I have a kid and that my kids get sick, and that's a normal thing. And my manager can understand and refrain from disciplining me. If, however, my manager procedurally, as a way the work is organized, does not have the latitude to do that, I just clock in and my pay is automatically docked, or I'm automatically disciplined in some other way, my manager has no way procedurally to do anything about it. So that's a sort of cardboard example of what we're talking about when we say loss of human agency. System says no, right? So these provisions are aimed at addressing these risks, and the paper kind of explains this in fairly pedantic detail if you're really, really interested in the kind of theoretical apparatus behind all of this and the economic analysis. There are two other categories of risk that I want to note that are not sort of set out in such meticulous detail in the paper, but I want to mention them at least briefly. The first is health and safety. We know that algorithmic management systems, especially rating systems and quota systems, can put workers' health and safety at risk. We know quota systems can push workers to skip breaks or drive too fast in transportation and logistics. In the context of on-location platform work, especially, we've seen pretty egregious cases of rating systems having really alarming occupational health and safety impacts. We know that if customers can rate workers and bad ratings can get workers deactivated, fired, right? Fired. We know that these systems can effectively pressure workers to accept unsafe or inappropriate requests from customers. Transporting illegal drugs is one that's been documented in the social science literature. Enduring sexual harassment is another one that's been documented in the research. So the provisions that we set out in the paper that I've articulated quite briefly here aim to create much more transparency around how these systems work, and also procedurally to create more worker agency and oversight in their design and use. So if something like this is happening, you have worker representatives who have a procedural point of intervention to say, look, this is what's happening. We have to change this system, or we have to stop using the system. The last thing that I want to point to is bad decisions. And this might sound silly, but here's an example. Let's say you're a hiring manager and you use AI to screen the CVs or resumes of applicants for an open position. That sounds like a reasonable sentence, but what does it mean? I'm going to use AI to screen the CVs. Well, it might mean that your software scans the CVs for keywords and counts the keywords and ranks the applicants, and it would rank an applicant higher if they have more of the right keywords. But which keywords are the right ones? How do you decide, right? Do you ask the AI to decide? Earlier, I said an algorithm is a procedure for doing a task. And in this case, the procedure is based perhaps implicitly on assumptions about what makes one candidate better than another. I have, perhaps implicitly, or the programmer of the algorithm has, a theory of what a good candidate looks like. And if the theory is wrong, the procedure will be wrong and the decisions will be bad. They may also be biased and unlawful. We know that humans make bad hiring and management decisions all the time, but the risk with algorithmic management is that organizational leadership assumes that because the decisions are made by AI, they are good, scientific, rigorous, objective, unbiased. Of course, we know that that is not necessarily the case at all. These systems are just products made by people. They can have and do have defects, just like any other product. And I just love this investigative research by this journalist, Hilke Schellman, where she tested these AI video interviews. This is a few years ago now. And she spoke in German, and it still gave her a high score for English proficiency. So just completely absurd outcomes. This is another one. This has been fixed now, but just mind-bending stuff. And we're like, oh yeah, this stuff, obviously I asked AI, and that's the end of the story. AI knows things. No, no, it doesn't. So we're getting close to the end now. I'll touch on two more questions and then conclude. Is this overregulation, and what now? So my theory is that no, this set of proposals is not too much. It's not over-regulatory. Why do I think that? So 2 years ago, maybe 2.5 or 3 years ago now, these two Princeton computer scientists, Arvind Narayanan and Sayesh Kapoor, published this book, AI Snake Oil. It's about why some AI does not do what it is claimed to do, mainly. But they say something in the very beginning of the book about how we talk about AI, which I love. And they say, imagine that we did not have separate words for cars, buses, trucks, planes, boats, cargo ships, rocket ships, motorcycles, bicycles. But for all of these things, we had only one word, vehicle. And we were having research and policy debates about how to invest in vehicles, how vehicles will transform business, how countries should regulate vehicles, whether they're being over-regulated. And they say, this is how we talk about AI. This is how we're talking about it. And I think they're right. We should think about AI and digitalization generally, similarly to how we think about this category of machinery, vehicles. Should we invest in AI? Should we regulate? What jobs will be lost and created? What's too much regulation? Think about how we use and regulate different vehicles. Some vehicles are climate friendly, like bicycles. Airplanes are another kind of vehicle which are not climate friendly. Most vehicles require formal training, licenses, and insurance to use, but not bicycles. Different vehicles require different licenses. You want to drive a car? That's one kind of license. You want to drive a big truck? That's a different kind of license. You want to drive a bus? You want to drive an airplane? All different kind of licenses. We require different licenses for different uses. If you want to drive a car for personal purposes, well, that's just a driver's license. You want to drive a car for money? You need a taxi license. That's different. We have policy debates about which kinds of vehicles should be allowed on which roads in which parts of the city, whether we're going to have congestion charges for private cars in certain parts of cities, what times. They don't apply to bicycles or buses. This is so insanely complicated, but think about how normal it all sounds. We're used to having these debates. There's different kinds of cars, gas-powered cars, electric cars. These are different in some ways. How they're made is different. The number of jobs their production processes create is different. I worked for a trade union in Germany for 5 years, and we were panicking about the conversion to electromobility because it requires less jobs to put together an electric car. They have different supply chains. For manufacturers, these differences matter. For governments, these differences matter. For owners, these differences also matter. But for some purposes, the differences don't matter. The same speed limit applies to both. AI and digitalization are also like this. There's different kinds of AI, different uses of digital tools, and I think we need more differentiated vocabulary when we talk about using them, investing in them, regulating them, just like we have for different kinds of vehicles. And now I'll get to kind of back to the first question, which I asked about this, which is this over-regulatory? Well, if we think about vehicles, we're not really worried that regulation will stifle vehicle innovation. We understand that regulation is needed for safety, and there is such a thing as bad regulation, but good regulation shapes good innovation. Many different regulations, regulated actors, and regulatory agencies are involved in vehicle manufacture and use. Vehicle manufacturers have one set of rules. Government agencies handle licensing of private drivers. Police handle enforcement. Of course, it's possible to make bad laws or for individual agencies or enforcement officers to do bad things. But I don't know if I've ever heard anyone argue that vehicles are overregulated. Right? So I think by analogy, you can tell me if you agree with the analogy, but that's my take at the moment. So now I'll wrap up. The first thing that I want to say is that this is a long project. This is going to be a long regulatory project. So in my home country, the United States, it was 70 years between the sale of the first car, if I've read my history correctly, and the establishment of agencies, the sort of big agencies to govern highway safety, motor vehicle safety. And we're actually, as painful and slow as it feels that AI and workplace data processing regulation is evolving, we're actually moving much faster in this area than we did in motor vehicle safety. But we have still, of course, quite a ways to go. And I'll just mention very, very briefly kind of areas of action that I think people in the room there are already doing more than I can recount and know on. And I think that that's crucial work. And I hope we'll get to hear about some of it. Collective bargaining, of course. Where does it happen in practice, right? It's the action is not all at the national legislative level, right? There's really impressive, really innovative, really informative agreements out there. There's databases that are collecting language for agreements. Professor Johnston has worked on one of them. I'm sure there's other people in the room who've worked on others. There's 4 or 5 big ones now that I'm aware of, at least. We can talk about some of this in the discussion. Of course, national policy advocacy. I don't know if there's an update to the Canadian data protection law planned anytime soon, or if there's political momentum for something like that. In other countries, we've tried and failed a few times now. In the US, that I don't think I need to say anything about what isn't happening there. But you're the experts in your context. You know better than me when the right time is. Strengthening enforcement. I work on EU data protection to some extent, and we've got a pretty decent law on the books, but enforcement is an enormous problem, including just resourcing the regulatory agencies. Education, of course, this includes educating workers, building trade union capacity, but also managers, right? These issues are really complicated, and my experience has been that a lot of times management does not understand the technologies that they are buying. And that's a problem for organizational sustainability, just even from a purely managerial point of view. And then finally, at the international level, there's important initiatives that are underway. For example, at the International Labour Organization, the UN is standing up this new international scientific panel on AI. We don't know the list of names of people who are going to be on that panel yet, but once that comes out, we'll know something about the direction that it is going to go in, whether it's going to be this kind of deregulatory vibe or it's going to be something more substantive. So there's a lot going on. And I'm looking forward to hearing from you all. Thank you very much.
Thank you so much. Before we open questions, I just want to take an opportunity to sort of bring this a little bit more into the Canadian context. And I will start with, I will conclude my comments with a first question for you. In this sort of spirit of talking about regulating vehicles, right? When we use public roads, one thing we've decided is that if you're going to use an, gas-powered or electric vehicle, we ought to have something called a license, right? And you began by talking about data protection rights. And we've just come off of our last panel, which spoke about monitoring and surveillance and the collection of data about workers in the course of their employment. That panel did a lot of the work, I think, for me. But if we were to sort of think about what is personal data, right? And identifiable information about a person or something that could potentially make a person identifiable, your name, your social insurance number, maybe your IP address, maybe your phone number, right? This kind of information. But this is information that we are producing both in our personal lives and in the course of our employment. And the data protection regime that we have in Canada right now, the last panel made the point that particularly in the private sector, which many of the folks in this room come from, there's a massive gap, right? And that is a giant carve out about data that is produced in the course of work. So PIPEDA, which is our sort of private governed sort of data protection rights in the private sector, if it is data that is produced by an individual in the course of their employment, there is even exemptions for consent from workers if the data is necessary to establish, manage, terminate an employment relationship. So if we think about something like management, right, and this sort of data-driven management, algorithmic management, those data are the building blocks for the kind of AI and algorithmic systems of which you have given us many examples. And so even though we have sort of some notification rights in here and we have opportunities maybe for collective bargaining and things like this, when we think about closing these gaps in Canada, can we start to think about regulating AI or algorithmic management without addressing the questions around data protection or without addressing those first? Does that need to be a precursor? I would just be curious to hear your thoughts on that.
Something that I find interesting, you know, I'm a computer programmer originally, and now I work in this Institute of Human Rights. And I find that often with legal scholars, people articulate a question which sounds like it's a question about law, but it's actually a question about political strategy. And so my answer is, I don't know. You guys need to figure it out. You are the experts in your context, right? So the answer to the question is another question, which implies a procedural answer, which is what is politically feasible, right? What can you do politically, right? And this is literally about political coalitions. It's about alliances. It's about timing. It's also about the procedures, right? Is it easier procedurally and politically to introduce a brand new law than it is to introduce an amendment to an existing law, right? If there's a procedure for adding 2 lines to a law, then that's like somehow easier politically or procedurally than getting a whole new law. Then like, yeah, that's great. Then we can add 2 lines and saying personal data is to be defined as follows. And, you know, Article 77, paragraph 333 is deleted, right? And that's the carve out, right? Sure, great. If I can push that through with nobody noticing, I'll take it. But I think really this is a question of like looking at the law, looking at the text, thinking about how that's interpreted juridically, and thinking, okay, we understand that there's a carve out here. What are 5 different ways we could imagine to change this law to get rid of this carve out? And if the answer is like none of these are going to happen, okay, well then we need to build a campaign to get something completely new. But I think, you know, unsatisfyingly for me and maybe for all of you listening, I apologize, but the answer is like it depends. It depends on the political context. It's not about the law, right? That legally it just has to hang together. It has to work, right? It has to work. And judges have to be able to understand, okay, this has now been changed in a way that means this carve out doesn't exist anymore. And I mean, in California, we saw this, right? The early version of the privacy law was called the Consumer Privacy Act, and it didn't apply to workplaces. And then the next year they were like, oh, we've made a terrible mistake. And everyone was like, yes, you have made a terrible mistake. Fix it. So sorry if it's not a very satisfactory answer, but my point is like, you already know how to figure this out because this is the expertise that you have as trade unionists in that setting.
I will ask you another question, and then I would also invite folks to come up to the microphones if you have questions you would like answered. You made a point about sort of this kind of detailed and granular information about individuals that's collected and how that can sort of encourage bargaining at an individual level. And one of the things that I am interested in is around sort of data collection, data use, and the broad sort of processing of data, regardless of sort of how we do that, whether that is with the more antiquated algorithmic systems or with AI systems, what it means to have this trend that we're starting to see in some collective agreements about allowing individuals to opt in to systems. And I have a lot of concerns about that. And some of my concerns relate to the fact that there's information collected about what you do and also what you don't do. So imagine you have a team of 5 people and 4 decide that they're fine with their employer collecting information about them because it is easier or because the technology is convenient, right? If you have the performance of the team, you can then impute information about the performance of that 5th person. And this is one of the reasons why I think this is like fundamentally like we need this kind of collective response that you're calling for. And so I guess I'm curious about sort of how you weigh this kind of like individual interests versus the collective interests. Do you think that that those sort of collective rights should always sort of supersede the individual ability to opt in? Do you think that's a bad strategy to have individuals be able to consent? And I guess when we think about like reducing this widening power differential, like how do you do that in this age of like informational asymmetries? So like, could you do it also think about doing it through things like procurement? What does it mean in terms of who we have at the bargaining table? Right, like you made the point about mid-level managers, but these technologies are often implemented in IT departments. The people that we negotiate with are often like C-suite folks or legal counsel or HR departments who aren't necessarily part of the rollout of these technologies either, right? So just wondering if you have some comments on that as well, and then we'll have some questions from the audience.
So I'll try to reply quickly in reverse order. Like, if I'm negotiating with someone who's top management and they don't have a clue what's going on, obviously that's a problem. And my task then is to explain to them why that's a problem, and they need to bring the people in who have a clue. But that's this sort of like really challenging pedagogical task that we have as trade unionists or researchers even who are kind of union side in these debates, where management just wants to like get out of the room, go home and be like, oh, I've got that. I don't have to deal with them anymore. I'm done dealing with them. They just want to be done, right? And part of the task is to be like, no, you don't want to be done because there's something going on in your company that you need to understand. It's your job to understand this. And once you understand it, then we can negotiate like sensible people. So it's hard. It's hard work. But we know that negotiating is hard. So that's one thing. Collective and individual opting out, opting in. I mean, look, do we let people opt in or opt out of minimum wage coverage? Child labor prohibitions? Can I, if I'm 15 and I'm like, oh, but I just really want to work, can I just opt out of the prohibition on child labor? Like, no. So, there's probably some context where it's fine. But in general, I think, we make laws so that there's a floor, and we make collective bargaining agreements so that there's a floor within the company or the bargaining unit. And if we then say like, okay, we went to all this effort to negotiate and agree on this floor, but if you want to get paid less than minimum wage or whatever, like then that's fine. Like, okay, I understand that there are political realities, there are bargaining realities. Like oftentimes the negotiators are not giving that to management because they want to and they think it's a good idea. It's just something that they've caved on in order to buy something else, and I understand that. But in terms of what we're aiming for, I think the way to think about these prohibitions and protections is normally that they're like minimum wage, they're floors, and there shouldn't be derogations or opt-outs or like if there's something that we think is harmful, well, then our position is that it's harmful and it shouldn't happen. So, maybe that's too simple. I'm happy to hear criticisms, but that's my first response.
Thank you. I will read first. We'll have two questions together. I'll read one that we've received online, and then we'll take one from the audience here. And then I will pass them both to you, Six. This comes from someone who is located in the EU, and it is focused on GDPR. And it says, even in the Platform Work Directive and the Parliament's legislative report for algorithmic management at the workplace, collective data rights are not robust enough. In terms of legislation, where do you see the most promising way to enhance this collective aspect of rights for access and complaint, or maybe even further for ensuring a legal base for worker data trusts and collective governance? And then if we can have our second question as well, we'll give them both to you.
I'll answer that really quickly. And I'm just going to be super annoying, and I'm sorry to Johannes. I think it's a phenomenal question, but it's not a question that can be answered by like the sage on the stage pretending that I know something. It's a political question. We have to figure it out. Like, we're going to Brussels constantly and like lobbying the policymakers and putting out papers and blog posts and making these arguments. And like, what is the most promising venue? Like, I don't know, whatever's politically feasible. Maybe Valerio has another take, but that's a strategic question. It's a political question. It's not a legal question, as far as I can tell. It's a great question. It's an important question, but it's not a question that we can answer like in this room.
Great. We'll take our next question from the audience, and then we will indeed turn to Valerio for his comments.
First and foremost, thank you, Michael, for the presentation. Very informative and a lot of nuggets of wisdom to take in mind. I won't keep you too long. Just have a quick question. Let me see here. 1, 2, 3. Okay. Based on this regulatory framework, where does algorithmic bias come into play when the AI makes a decision that can breach the rights of the worker, and what enforcement mechanisms would be in place to mitigate things like occupational health and safety risks? So I promise you this is not a political question, but it's really meant to be a question to highlight the things that are within the framework itself, but at the same time to, state what's obvious. AI is not perfect, it's not real, it's not God, right? So, that's kind of the lens I'm going with. Thank you so much. Merci beaucoup.
Thank you. So no, you're right. That's not a political question in the sense that it's a substantive question. It's a legal question. Where does it sit within the framework? I think we have a difficulty in the EU context, and this is maybe some translation work that I should have done in this presentation. But we have a presumption, not in the sense of a legal presumption, but a basic principle of data protection, which is that the processing of personal data under European data protection law must be lawful, fair, transparent, and a few other things. But lawful, fair, and transparent are the sort of core. And lawful means that you cannot violate other regulatory frameworks like anti-discrimination law or equality law, as they call it here in the UK, right? So it's this kind of basic thing that is already there, and it's sort of taken for granted in a lot of the EU discourse around this, which can be problematic if you kind of lose sight of it, and then all of a sudden you're having a discussion in which it's sort of implied that somehow data processing might be unbiased. So I think the sort of unsatisfactory answer is that in the presentation I have not foregrounded it. There's discussions of how do you deal with discrimination procedurally in the paper. If you have a more specific question about that, I can try to answer that. But I think the answer to your question is we rely on the existing anti-discrimination law framework. I think that's the shortest, most direct answer. And I think that's you asked about occupational health and safety, Osh. I think in the European context, the answer is the same, right? So you have the Occupational Health and Safety Framework Directive in the European context, and you have other nationally specific occupational health and safety laws. And so the idea is that the framework that governs algorithmic management interlocks with these other existing frameworks. Like, I don't think, now I'm venturing into sort of strategy here again, which maybe is unwise of me, but I don't think that as in a sort of data protection and labor instrument, we want to be reinventing sort of core bits of anti-discrimination provisions, with potentially one exception, which is the burden of evidence, right? So there's an interesting, really interesting paper by Ashlyn Kelly Life in the same special issue that paper is from. So if you want to look up the paper on that, she goes into a lot of detail, sort of articulating how one of the real challenges in the UK anti-discrimination framework procedurally is that the burden of proof is on the claimant, right? The person claiming that they've been discriminated against. And obviously, this has always been a huge challenge, but in the context of algorithmic management, it becomes a much bigger challenge unless you have rights to information access and the employer says, oh yes, here's an explanation of the decision-making procedure. And you can be like, oh, you had this machine learning program that was trained on the CVs of all these, male programmers, and that was why I didn't get the interview, right? So, but employers are typically reluctant to give out that information, and they'll use all the data protection exemption tricks that they have access to. And so I think in this context, the one procedural point that I would make is it has to be for the employer or the controller to prove compliance with anti-discrimination law rather than it has to be for the plaintiff or claimant to prove that they've been discriminated against. And that is a bit of a procedural challenge in the context of existing equality or anti-discrimination law. But it's something that kind of is more consistent with the spirit of data protection law, which sort of puts the burden of proving compliance on the controller. So I don't know if that really answers your question, but I can point you to that paper if that's something that you want to bite into in greater detail.
Thanks, Valerio.
Thank you, and hi, Six. So first of all, on behalf also of the other organizer, I would like to thank Six, who basically stepped in at the 11th hour, because our original speaker is colleague Jeremiah Salam Prassel. He's also an associate dean for research at Oxford, and the role of associate dean is to put out fires, and he had to put out a fire, and Six has really graciously stepped in at the 11th hour, and we really appreciate that. I have an observation and a question. An observation based on what you just said about the lack of information from the management side, when the management doesn't know what the systems are doing, what the machines are doing. And it is true that compared to European law, Canadian law tends to be less protective on many aspects. But there's one thing actually in which Canadian labor law is much stricter, is when you show up on a negotiating table as a manager and you don't know how to answer questions because you don't have enough information, that's when you can violate the duty to bargain in good faith. It is a violation of the duty to bargain in good faith to say, I don't know about what's going on in the machines I'm deploying that can affect wages, working time, discipline, and all that. To say, I don't know, it's simply not good enough. And I think we should start to think about these systems more, not just from the angle of privacy, but also on the angle of these are things that affect working conditions. It is the realm of collective bargaining. And so unless you know, you should be in trouble, and you cannot just say, I don't know, as you are not able to say, I don't know, when someone asks the pay level in a certain department of your organization. Which brings me to the question, because I of course I know and appreciate the blueprint, and the blueprint that you guys have put together is a blueprint for, if you want, legislative and policy action. But I think this side of the pond, it's quite important, I think, to also think about how to use collective bargaining strategically. Also because collective bargaining is the closest thing that can come to regulations, the closest kind of regulation that can happen when things matter. And I was wondering whether you were in the process or were considering coming up with a sort of blueprint for collective negotiations, not just on policy, but more specifically on collective bargaining.
Well, first of all, I love this duty to bargain in good faith. And I think what's really interesting about the argument that you make there is that it sort of rhymes or resonates with kind of the more general arguments that we've heard from this sort of interdisciplinary data protection and labor law scholarship and some of the computer science work as well, which is making the argument basically, if I can kind of sum a lot of good and nuanced work up in half a sentence, like workplace data processing is about working conditions, right? And this was kind of the argument that we had to make in the first few years of this work, where it's like, look, data processing is not about privacy in the traditional sense. It's about working conditions. So I think, what you're saying there is to sort of make a similar argument, and I think that's potentially quite useful. In terms of making a blueprint for collective bargaining, so with my trade union hat on, so I'm also consulting with the International Trade Union Confederation on digitalization and AI. And one of the things that it looks like we're going to be trying to do this year, I don't know if it's going to be framed as a blueprint, but kind of foreground some of the, really excellent work that is being done by trade unions all over the world already, and just to kind of bring some of that work together in one piece of research and translate that into a few languages so that it's a bit more broadly accessible. And probably we will lean fairly heavily on these databases that people have been putting together already. So I don't think it's going to be an enormous intellectual contribution on our part. I think it's just going to be kind of like using the ITUC megaphone and saying, like, here's some really great work that trade unionists are already doing all over the world. But hopefully that will begin to kind of spread the awareness around that. Like, these are questions that can be answered through bargaining. This is not insoluble, ungraspable stuff. As I think if I remember sitting in Brussels in 2016 and hearing policymakers and trade unionists just sort of panicking that they had no idea how to deal with any of this. And I think, in the last 8 to 10 years, we've really, as a trade union movement and as an academic research community, really started to get our heads around it. And I think I'm much more hopeful now than I was then, at least about the kind of bargaining level activity.
Of the things that you've outlined in the paper, is there anything that you feel could not be addressed through bargaining, given that on this side of the pond, that is perhaps our most maybe dynamic and immediate way to engage in some regulation and oversight within our workplaces?
In any political arena, depends on the resources of, like, what can be achieved through a particular political arena depends on the resources that the relevant actors have at their disposal, right? To invest there. And I think it's been interesting to me to, having moved from the United States, been working in Germany for 5 years, and then collaborating with colleagues in the trade unions in Sweden for the first couple years. Whenever I would listen to the Swedish colleagues, I would just be so baffled by them. I'd be like, what do you mean you don't want minimum wage? And they would say, well, if there's a national minimum wage law, it undermines the incentive for people to join unions and do collective bargaining. So we want the unions to be the actors, the agents, the powerful actors that do wage setting. So I don't think that there's anything inherently impossible to regulate through bargaining, but bargaining is hard, right? So, if you can get a framework that gives you certain levers in the bargaining process, or sets certain floors below which it's not possible to bargain, that gives you procedural power or rhetorical power that you otherwise don't have. So I think, again, the probably a very unsatisfying answer to a really important question on the context, right? What is going to be harder and what is going to be more straightforward? And at some point, let's check in 4 or 5 years, we will know what we have not been able to get through bargaining. Not because it was necessarily impossible, but at some point, things become, policy priorities for advocacy at national level, at the confederation level, because it has not been possible to bargain them, comprehensively at the company level or at sectoral level. So again, probably not a great answer, but an important question.
No, I hear what I hear you saying is like a multi-pronged approach is really good, and get organized and try, right? Are there any other questions from the audience? Yeah.
Alrighty, last call. So final question. By the way, that paper you mentioned, if you could, if possible, to get the paper you referenced, that would be really great. I'd like to read it. I'll actually read it, I promise. So here's my second question. Based off of the research from what you mentioned, of course, how do you restore human agency in the deployment and governance of algorithmic management systems in the midst of technological displacement? The reason why I mentioned human agency, because it's the priority, it's the foundation, and it's something that unfortunately gets ignored too quickly. So I want to bring it back to human agency, and most important, of course, to my question, how does that fit into the context? Thank you. Merci.
So I have just pasted into the chat to host and panelists. I don't know how to get that out to you, but that, I believe, is the link to the paper about algorithmic discrimination at work. And it's really about this kind of interaction between using data protection law rights to get access to information, which can then be used in making the case for discrimination if discrimination has taken place. How do we restore human agency when jobs are being displaced, when people are losing their jobs? Did I understand that? You said that very correctly, and I just want to understand. I want to confirm, when people are losing their jobs, is that right?
Let me repeat for those in the back. How to restore human agency in the deployment and governance of algorithmic management systems in the midst of technological displacement. Hope that was clear.
Displacement. Yeah. I mean, when I hear technological displacement, I hear people's jobs are being taken over by the machine.
Bingo.
Yeah, all right. So, I mean, I think that's hard, right? Because once people have lost their jobs, they're not there anymore. They're not covered by the framework. The relationship is destroyed. So whatever framework applies, before they lose their job, it does not apply anymore. So, this is a question about timing. This is a question about we may have a good framework for ensuring that when management proposes to introduce something, the people who are represented, who are currently employed and who have worker representatives inside an existing organizational structure have some sort of say. That's kind of that's the orientation or the objective of the set of proposals. If we have a larger structural situation, which I think we're starting to see is what we're going to have now, this becomes a much bigger question, right? This becomes a much bigger question about labor market policy. And it's not really a question about what's happening within the organization anymore. So I think I'm not giving you a good answer. I don't have a good answer to that question. And maybe the answer is like, let's get a framework that addresses these concerns into place sooner rather than later, because if we can get it into place before people lose their jobs, then they're in the structure. But if we can't do that, then I think we're in a lot of trouble.
Yeah, and certainly a cross-cutting issue. And I suspect we may hear some strategies maybe at the panel that we have this afternoon too, about how some unions and their groups are responding. So if there are, one more question for 6. Yeah.
Hi, thank you for the presentation, and really nice to see fellow engineer and also working in research for human rights. So my name is Arshi. I had a question about the blueprint. So I understand how this, the enforcement might work in a formal work environment where the employee-employee relationship is clear. Having worked with, largely gig workers and platform work, something I was curious about is how would this be enforced in informal work relationships where workers are largely, in the global south, for example, have in India or Indonesia, where they have where the bargaining power is lower and where there is large pushback from these corporates and these companies, these tech companies, where they say, hey, if you regulate us more, we will just take away your jobs and then you have nothing. And there's this fear factor. So, and in that situation, that context, how would we enforce this blueprint or these provisions, or would we need something additional in that?
You need something additional, which is a political strategy, right? So this is a legal instrument. This is not a political strategy. The political strategy has to respond to the challenges of the particular context, right? And I would just say this thing that employers say, or that gig platforms in particular say, if you don't let us continue employing people while not treating them like employees, then we're going to go somewhere else. I think, as a trade unionist, as a researcher, my task in that moment, when the policymaker comes to me and says, oh yeah, we agree these people are being misclassified or they need to be regulated in such and such a way, but they tell us that if we regulate them, then they're just going to leave. Then I think it's my job as a kind of advisor to tell the policymaker, let them call their bluff, because what's going to happen then? Whatever big multinational is going to leave, and then you'll have a locally based alternative, and that will be good. And yes, people will lose their quote unquote non-jobs, right? Which are apparently not jobs because they're just entrepreneurs, according to the platform company. Fine, go. We'll sort it out locally. We're capable people, right? That would be my answer. Call their bluff, because mostly they're bluffing. And this actually played out also in the global north in certain contexts. Austin, Texas, in the early days of Uber and Lyft, maybe close to 10 years ago now, said, dear Uber and Lyft, all your drivers have to comply with the same safety regulations that the taxi drivers have to comply with. This was Austin City Council in Texas. And Uber and Lyft got together and they said, no, we don't want to do this. If you do this, we're going to leave Austin. And the city council said, fine, leave Austin. And they did. And then what happened was that there were homegrown alternatives serving only Austin for several years. And 4 or 5 years later, Uber and Lyft were like, oh, it's okay. We can be grown-ups. We'll comply with these safety regulations. And they came back. So I think it's a bluff. And I think the word that you used was the right one, fear. It's about fear. It's a rhetorical game. It's a political game. And I think, it's the policymaker's job to understand that, like, the regulatory framework is the regulatory framework. This is the floor. Don't bargain with, like, dear corporates, don't bargain with me over having the rules not apply to you. It's my job to hold you accountable to the rules. And obviously there are practical considerations like building enforcement capacity in the responsible regulatory bodies. This is a huge challenge. This is a huge challenge in rich countries too. The huge problem in Europe, it's a huge problem in Ireland, as I'm sure you can imagine, where all the US multinationals have their European headquarters. Enormous problem. But that is the task for the next 5 to 25 years, I think.
Well, thank you very much again, Six, for joining us, and especially on such short notice. And we'll just give another round of applause. And we now have a break of 15 minutes.
Okay, all right. It's 3:30. We'll get started. I know it's the Unifor crowd in the back that keeps talking. I get it. I know. It's not Sammy and Jen. We know, Lana knows it's not Sammy. So a few things before we get started here. One is, well, obviously this is the last panel of the day, best panel of the day. I know it's been a long day, but a wonderful day. So one thing I will say is just to give Valerio, Roxanne, all folks who were involved in the planning, just a big round of applause, because I think this has been also, just to thank the interpreters who have been doing a great job for us all day. So also a round of applause for them. There will be some housekeeping items that I've been charged with, which may or may not go very well. So hopefully I don't screw this up, but make sure, just quickly, I'll remind people after, there's a reception after this panel. It will be in classroom E. You'll have to leave your headsets on the tables, and we're not rushing people out of here, but you got to move pretty quick because there's another class that they're setting up for in this room. So I will remind you all of that afterwards. I think this is a great way to end the day. This panel, the topic of it is around AI responses, but I think it's safe to say what we want to do is dig a bit into AI strategies. I think three things we're going to try to accomplish. We want to bring this conversation down a few notches, get closer to the ground level, and situate it within the regulatory framework. So, you know, how we've been doing that quite a bit through the day, but also a workplace and collective bargaining context as well. And where we can, through a worker's lens. I think this will tie a nice bow on how the day's gone so far. We want to make this practical and accessible, which I think will be really useful for the trade unionists in the audience, and hopefully hear more from them in the discussion portion of it, which I think will add a richness to this. And then because of the speakers that we have, we are going to be able to also draw out some interesting comparisons and drawing out some conclusions across three different jurisdictions: Canada, the United States, and Europe. What I'm hoping we can do is start getting into a discussion of what ought to be done, what is being done to ensure that we are reducing or mitigating the risk of very rapid AI adoption and new technology adoption, and where workers can reap the benefits, which is always the tension, regardless of which wave of new technology we're talking about over time. I'm going to introduce our panelists, and I'm going to go from my left to right. Our first speaker will be Laura Caroli, also known as Laura Caroli, for Americans, any Americans in the audience. She is a former senior fellow at the Center for Strategic International Studies, working on AI governance and regulation, and also spent 10 years at the European Parliament and led negotiations on the European AI Act at a technical level. So it's great to have her here. Next, we have Virginia Dalgast, also known as Ginny, and she is the Ann Evans Estabrook Professor of Employment Relations and Dispute Resolution at the ILR School at Cornell University. And finally, Sarah Ryan, also known as Sarah Ryan, is a Senior Research Officer at CUPE National Office in Ottawa, with a focus on artificial intelligence, employment insurance, and housing. She coordinates CUPE's working group on AI and is keen to equip workers for this new wave of technological change. So welcome to our panelists. It's great to have you here. What we're going to do is give each of you 10 minutes to offer your perspectives and from your different perspectives. And then I will have a couple questions after each of you speak, and then we'll open it up and we'll wrap this up. Should be great. So let's start with Laura. Go ahead.
Thank you, Angelo. Thank you so much, Valerio, for inviting me to this very interesting conference. I've learned a lot today. And I think this being the last panel of the day is particularly good because it, for example, for what I'm going to talk about, it leads me to already reacting to a few things that have been said and put the basis of what I'm gonna say. So I'm gonna start by giving you a bit of context of what the AI Act does and cannot do on workers' rights, because the AI Act does not regulate everything AI. It's a risk-based regulation that is, by its nature, a product safety type of legislation. I don't know if you know, but you're not supposed to certainly, how the European legislative process works. Please don't be afraid if you don't. So basically, regulating this whole area was a major challenge. One of the main reasons I think we managed to do it, unlike other jurisdictions such as the US and Canada too, is because it is the European Commission that makes the legislative proposal in Europe. So it is a bureaucratic and executive body that has a lot of resources to conduct studies and to draft legislation, and then Parliament on one side and then the governments of the member states on the other side form their specific positions on this proposal. And then these two positions have to be negotiated together in a final stage of negotiations. This whole took 3 years to do for the AI Act. So it was a long process. Compared to the first draft, what came out in the final negotiations was a much more substantial improvement and attention of workers' rights. Even though, let me first clarify one thing. The EU AI Act does not have the correct legal basis to deal with employees' rights, workers' rights, because as I said, it's product safety legislation. It's supposed to harmonize the single market. So it's more targeted at providing uniform requirements for AI considered as a product circulating in the single market. So what we did on workers' rights is just basically we did as much as we could without changing the nature of the law. This is very important to clarify because, of course, the AI Act has shortcomings when it comes to workers' rights, and it's because of this reason. It's because the intention was not to establish a ceiling of what workers' rights should be in the context of AI at the workplace, but rather a floor, if you will. So some basic minimum protection that was not already tackled by GDPR or by the Platform Workers Directive. The Platform Workers Directive, by the way, is a specific labor legislation. So it has the correct legal basis and it could introduce rights and specific provisions, which the AI Act could only do in a limited fashion. So basically what the AI Act does is, first of all, it starts by saying that the AI Act doesn't preclude specific labor legislation on AI at the workplace, both at the union level and the member states level. So basically, we left the door open for the European Commission to come with a specific directive on AI at the workplace, which has been in the debate for a few years, and maybe I'm going to say a few words at the end on this. Second, as other types of legislation, even the failed AIDA here in Canada tried to do, it puts work-related use cases in the high-risk area. So basically, hiring decisions, termination decisions, but also in the final version, task allocation based on profiling, targeted job advertisings, and the negotiation of the terms of the working relationship, work-related relationships. They are high risk. So basically, this means that providers that sell, vendors that sell AI systems to employers that want to use them for these purposes that I just listed, need to perform to make sure the AI system has specific complies with specific requirements. So data governance, make sure there are no biases and they are corrected. The data quality is right. The data is representative, etc. A risk management system, transparency of information to the deployer, who then will have to use these systems on workers. Human oversight, providing for human oversight, cybersecurity, accuracy, robustness, to make sure that the AI system performs consistently and as accurately as possible. So this is on the side of vendors who designs the AI system. Deployers on their own hand also have obligations. They have to perform this human oversight. So it means there has to be a human revision of a decision that is made by AI, if ever, and also collaborate with authorities, etc., etc. In the work context, we also added, very importantly, that deployers, so HR in a company, whenever using an AI system on workers, whatever AI system they use on workers, they have to inform the workers and their representatives that they are using an AI system on them. We have heard today of many, many worrisome cases that perform monitoring and even invasive monitoring of all kinds. We cannot say they are prohibited, but workers need to be informed, and especially workers' representatives. This is one of the major successes that we had even personally, me and my former boss, because this is an inclusion that we added in the AI Act from a socialist perspective. My former boss was a socialist and Democrat member of the European Parliament, actually still is. And so we were always particularly sensitive to this area. So we did as much as we could within the boundaries of the law to make sure that we would protect as much as possible workers' rights. One other major success that we had was that we did obtain a ban that is specific to employment, workers' rights, which is a ban of emotional recognition at the workplace, also in education, actually. Why? Because we thought, and we made clear to our counterparts that were negotiating with us that the workplace and education, we also wanted other sectors, but I'm not gonna enter into this, are sectors where the imbalance of power is particularly strong. And so there is no way that performing emotion recognition on a worker is going to be positive for the worker, or nor that the worker might be necessarily okay with it. We also heard the debate on opting in, opting out. We don't care. You cannot do it. You cannot waive this right. We also banned biometric categorization, which is useful because it prohibits the use of AI systems to infer sensitive characteristics, including the political orientation of a person based on biometrics, or political orientation, or adherence to a trade union. So, I mean, trade union membership. This can also lead to possible inference of, is this worker gonna go on strike? Is this worker gonna be difficult, et cetera, et cetera. So it's very, very important that we ban this. We also have introduced a fundamental rights impact assessment. So deployers that are public authorities or banks or insurance need to be aware of the rights that might be affected of specific groups of people by the use of their AI system that they want to deploy internally. We also have a right to obtain an explanation, similarly to GDPR, a right to obtain an explanation as to why a certain decision was taken by the AI system. But unfortunately, we could not obtain a review of this decision. So this is something where there is still room for improvement. And this is why we are still, the Parliament is still discussing the possibility of this future legislative instrument, even though on AI at the workplace on AI at the workplace, there was just in December a resolution. This legislative initiative resolution was approved in December by the Parliament. And among the several demands, it's actually toned down from what we were asking at the time, because one thing I should mention is that times have changed also in Europe around AI. And this is very important. Majorities have changed, political majorities have changed. This is a very, very key aspect of what one can achieve and the strategy and the alliances that need to happen in order for such measures to be included in legislation. It's like it has to be a combination of positive coincidences, let's say, that we luckily had during the AI Act negotiations, but are not there anymore. I can tell you that. And you might have heard Europe is now trying to simplify both the AI Act and also GDPR in a way that we might not necessarily like, because it's eroding a few of the protections that we obtained. Nothing that I mentioned specifically. So the specific parts on workers' rights are still will still stay. But for example, there is this proposal of a postponement of the entering into application of these high-risk rules by 1.5 years. So instead of applying already in August this year, the Commission is proposing now for them to start applying in December 2027, which is to us a caving in to employers, tech companies in general. So this is also an issue, like who is winning at the time today. Maybe their arguments are winning. They say we cannot apply this on time. There is no time. The standards are not there. So they are really, really very vocal and lobbying very hard. Parliament members who are very receptive from the right, unfortunately, and now have the majority. So it's becoming increasingly difficult. I took a few notes. I wanted to say that compared to what SIX explained in his blueprint, in their very interesting blueprint that they presented, I noted down every element and checked whether the AI Act does it or not. I have a majority of yes/no, because we do have prohibitions. We don't have a legal basis for processing of data, for example, because why? Because the AI Act does not have by itself the correct legal basis to tackle these issues. We do have individual notice because, again, employees need to be informed that an AI system is used on them. We do have sort of collective notice, yes, because also workers' representatives need to be informed, as we said, but they do not have the right to complain and negotiate, like to say just no, we don't want this. We do not have this right in the AI Act. Human in the loop for some decisions, yes, there is human oversight, but for example, we don't impose that hiring or termination decisions must be made by humans only, which is what the Parliament was proposing in the report that was approved in December. Among the few clear things that this report had, consultation rights, veto, again, no, we don't have this in the AI Act. Impact assessment, yes, we have the fundamental rights impact assessment, but it doesn't have to be the object of a public consultation with workers, because again, this was a compromise what we obtained, and we had to scale it down compared to our first proposals. But overall, I think we can be reasonably satisfied with what we obtained, and I hope this doesn't get eroded any further. So thank you.
Okay, great. Thank you, Laura. Virginia.
Great, thank you. So we have the difficult job of keeping you all awake. And I'm going to try to make some comments that draw on my own research, and also so I've been studying AI in the telecommunications sector, but I've been looking at telecommunications, call center work, technician work for about 20 years, and working closely with the Communications Workers of America, the CWA, as well as UNI Global Union, UNI ICTS on that research. So I draw on that, including a current project on AI and telecoms and game development, video game development, which has brought me more to the artist space and understanding more creative and cultural industries. And most of that research has been in North America and in Europe. So I can speak for the US a bit from that research space, but also give European cases. And more recently, I got to work with Janine Berg on an ILO working paper on global case studies on social dialogue on AI. So that was a great opportunity to look more around the world at the different way in which legislation, but also collective bargaining was really influencing worker voice over AI decision-making. So for my 10-minute overview, I thought that I would kind of frame the discussion in the way that I've framed the impacts of AI and the ways that workers respond across different projects. So I divide the negative or feared impacts of AI into 3 categories. And I always think about those categories as having the seeds of what labor's response should be in them. And this is kind of like Six's point that there are vehicles in general, which is AI, and then there are the specific kinds of vehicles, which is really how employers are applying these technologies in the workplace. And I think you've seen these different uses across today. So the 3 categories are first, labor replacing, the second, labor controlling, and the third, labor displacing. So labor replacing is automation of work tasks, where the concerns are really the impacts on skills, employment, and work organization. Labor controlling is our discussion about surveillance that was so rich earlier today, right? The automation of management, algorithmic management, surveillance, where you're more worried about the impacts on discretion, work intensification, safety, and then broader equity bias issues, data protection, safety kinds of issues. Then the third that we haven't talked so much about, but I think it came up in Janine's presentation this morning, the labor displacing impact of AI. So the use of AI to break up and relocate jobs outside of social protections. This does come up with platform work, right? Platforms apply AI in different ways in order to basically say that an apple is actually an orange, and employment is actually self-employment, right? To basically you're kind of disembedding work from the set of legal and social protections workers have organized to gain over time. But also this AI value chain is essentially displacing workers from one place to another by taking the jobs that used to be done in a particular place and then moving them to another place where they're being coded and controlled remotely. And you see unions starting to actually negotiate over this in places like the ports. But the example was given earlier about taxis, right? That there are these taxi workers are being displaced by self-driving vehicles, but somebody else is doing the work of coding in another place. So all three of those are kind of distinct action fields, I think, for labor, but also for policy, and need to be framed as such. And so if unions and policy are trying to respond, they want to move toward the alternative, from replacing workers to complementing skills, labor replacing to labor complementing, from controlling to empowering, and from displacing to embedding work and social and labor protections. And so I will give a few examples, right? Each of these different areas, I think, has different policy and collective bargaining goals and tools, but they also have different possibilities for coalitions in civil society and coalitions with managers on mutual gains, right? How workers, employers, and society can gain from better uses of these technologies. So if you're thinking about labor replacing to complementing, the goal of labor and policy is really encouraging employers to invest in skills, to expand good jobs rather than use tech to rationalize and de-skill work. That's a particular action field. And the mutual gains argument is also different. Workers are sharing their knowledge, they're using the tools in more productive ways, and they're producing higher quality services, art, media, healthcare, education for in our schools and in our universities, right? So these are all arguments that can be made to form coalitions with user groups, but also with more enlightened people within management who also want to meet those more quality focused goals. So unions and policy have, targeted things that they care about at the national level. Employment protections, a very basic thing that, of course, helps to underpin a lot of rights in Europe that we don't have in the US. National skill policy, retraining, and that has been particularly important. For example, in the Nordic countries, you have a lot of examples of these national social dialogue over skills and policy, skills and retraining, sorry. And then for artists, writers, and actors, basic things like copyright rules, intellectual property rights, image and ownership rights. These are also things about protecting your jobs, but protecting them from being basically replaced by these new, particularly generative AI technologies. Then at the industry and company level, you have agreements on job security, on outsourcing, and hard limits on AI use. So for example, UPS prohibits technologies that eliminate significant parts of the workforce in their contract. There are many other examples. And then joint committees and projects to invest in worker skills. So I'm just going to give one example in this area of SAG-AFTRA, the Screen Actors Guild in the US. So they were able to win AI protections in their agreements with the studios. First, studios can't make digital replicas of performers' voice or likeness unless they give advance notice and get written informed consent. And second, if the studios use digital replicas, performers should be paid the same amount as they would be for human performance. However, you have the Animation Guild, which is also negotiating. We haven't heard so much about them. They also got a pretty good agreement. It took them a long time, right? But in this agreement, animators can't opt out of using AI. They can't prevent work from being used to train AI models. And there was a recent agreement or deal between Disney and OpenAI, which licensed Disney characters to Sora for short form video. I don't know if you've followed this, but I did a lot of research recently because I was interviewed by NPR. So I had to quickly look up information on this and also call my union contacts and try to get quotes from them about what they were thinking about this deal. But basically, right, SAG-AFTRA was approached by OpenAI and by Disney before the deal. They talked about it. They definitely are skeptical of AI, but they were guaranteed we're going to protect you. So in that deal, they cannot use images of real people, right? And they can't use the voices of the animated characters, the voice actors, which are all protected under the contract. So it's, direct link there. However, animated characters can be used. So in a sense, this sort of unprotected space within these workplaces opens up. And then SAG-AFTRA, though, doesn't rest on its laurels. It's not just focused on its own members, its own contracts, but it realizes this point that's been made about the need for this underpinning for legislation that's protecting a broader group of workers. So they've been involved in trying to draft, for example, the Federal No Fakes Act, guaranteeing rights to voice and likeness, state level bills requiring consent for performers' digital replica to extend rights beyond their members, and forming broad coalitions around that. I don't know, do I have time to talk about one more?
Go for it. Yeah.
Okay, so labor controlling algorithmic management. So here, right, intensified monitoring, biased decisions, you want to move away from those negative aspects and more toward labor empowering, where workers actually have some voice, control, and basic limits on how this is used. And here, the mutual gains argument is different, right? Worker well-being is a key issue, equity, reduced bias. I work with a lot of HR faculty and teach HR students, and for them, this argument about like worker burnout is bad for companies and worker well-being makes happier workers who are more productive, right? They all buy into that kind of argument at some level. So for unions, I always work with unions, is like they want to organize and mobilize the workers, but they also want to make the performance argument at the same time, at least, in the US and Germany, maybe not in France, where sometimes that's anyway. So this kind of like idea about ethical AI as being good for their image as well as for customers often ties into this. I've looked at a lot of German workplaces, and you have these AI committees, and you talk to workers and managers, they say, having ethical AI policies, ethical AI committees, the companies are convinced it's also good for customers, that the customers see this company as being able to handle their data in a more ethical way if they're also doing this for their workers. And it's also actually not that much of an investment. It's not the same as guaranteeing you employment protections and guaranteeing we're going to put a lot of money into skills. Employers are more likely to say, okay, we just limit this stuff a little bit. How much does that really cost us? We can kind of, and so unions and policy responses here are kind of like building those coalitions to make those arguments, but then also getting in place the data protection, the performance monitoring controls, the information rights, privacy protections, and then through collective agreements, really establishing that AI-based tools should have human oversight, the human in control, and placing hard limits on the most problematic technologies. I mean, at the legislative level, as you said, the ban on emotion recognition is a huge deal, and the biometric category recognition. So here, I'll just give one example of the culinary workers in Las Vegas, where they did a project with their hotel cleaners. They were being forced to use this inefficient, stressful AI tool to map the rooms to clean, which was involved in their performance monitoring. And the union studied this and found that there were inefficiencies in the way that technology was mapping out the routes, but also had this negative impact on worker health and burnout and other kinds of things. And then they formed a partnership with the tech vendor to improve both the efficiency and the worker health and safety in that tool. And then they used that as an agreement with the major casinos employers that really placed hard limits on how they were using technology at work and their ability to use the tools. But the employers were also much more willing to partner with them because they could say, look, we also want to do this more efficiently. We've studied it. We've shown that your technology is not productive and efficient. And I think I'll end there just to say briefly that the labor displacing to embedding issue is really where you're making the argument focus more on equity, avoiding the race to the bottom, and international solidarity, and more broadly, protecting these rights across the supply chain.
Right, wonderful. Thank you, Virginia. Sarah.
Okay. Well, I'll just start by saying I found today absolutely fascinating. So thank you to all the organizers for putting it together. And I'm going to focus today on union responses to AI in the workplace. So to give you some background, QP set up an informal working group of staff on AI about 2 years ago now, 2 years ago in January, to start to think about how to tackle AI in the workplace. And we quickly zeroed in on worker education, collective bargaining, and worker organizing as some of the key components to protect workers. So worker education is fundamental, I think, for all unions when it comes to these issues. But for a union like QP, it is absolutely essential. We've got over 800,000 members in a multitude of sectors like childcare, education, energy, healthcare, municipalities, social services, and a lot of our bargaining units are very small. So we represent members at over 2,000 locals with over 3,000 collective agreements. Yeah, many of these groups are very, very, very tiny. And so we are the opposite of a hierarchical structure. So we really need to get workers excited and interested and mobilized to take this on, to take this to their bargaining tables. So workers do need to understand these issues, and it's not something that we all, I mean, I just started this work 2 years ago and have gone deep down the rabbit hole. I did not know all that much about this. And to be honest, I hadn't been thinking about what data is being collected by my employer, by anyone's employers, right? I don't think it's something that we've really turned our minds to. And the thing is, in a digital society where data is being collected left, right, and center, this is kind of core trade union work now. So it's really doing that work to inform staff, to build the knowledge of workers, and as well, so that they know how to spot what's going on, right? Because tech is being implemented all the time. Sometimes workers are aware, sometimes they're not. It's not something that a lot of workers are even focusing on. Like one of the activities we do is ask workers, what technology are you interacting with in the workplace when you go to work? And what comes out, like people struggle to think about all the different tech systems that they are using throughout their workday. So it's really, I think, the start of a conversation that's going to be ongoing, and that we're going to deepen the knowledge and the capacity of local leaders and staff to be able to take this on. So we've been doing a bit of a roadshow. We have multiple versions of presentations and workshops. We've been going to conferences, to sector meetings, to locals, to have discussions about understanding AI at work. We have developed a guide, which a member told me yesterday is very boring. And it is, it's quite boring. So this alone on the website does not do the job. And if we counted the number of members who have actually read this guide, I would put it at a pretty low number. So it's really when we get out and we actually talk to our members and build their knowledge, that we also we kind of build their knowledge, but we also get information about what's happening on the work floor. We are constantly just trying to map out what's happening in all these sectors amongst all the job classifications, because it's not a simple story. And technology and data is operating in so many different ways, in so many different spaces. And just getting a handle of that to begin with is a gargantuan task. So we are treating this like previous waves of tech change, in that we're trying to address the impact on workers, but we are recognizing as well that this is different in a lot of ways from previous waves of tech change, given the data and the algorithmic management that's taking place in the workplace that can fundamentally restructure power relations in the workplace. So we've learned as we've gone. I think when we started, we didn't have enough that was very tangible and concrete when we were talking to our members. So they weren't necessarily seeing themselves in the education that we were doing. And we've really started breaking down the risks into things that are that members understand and get, and that are concrete, right? Because that also dictates the response for locals. So are we thinking that there's a risk of job loss through automation? Are we thinking that there's electronic monitoring and surveillance happening? Is that data being fed into algorithmic management systems? Are these systems biased and discriminatory? How would we be able to tell that? How would we know that, right? So breaking down these risks into four different buckets so that workers have a more concrete way to spot the issues in the workplace. I was talking to someone and she was like, oh yeah, no, none of this stuff is happening. And I was kind of like, but don't some of the members, aren't they using an app like to dictate every aspect of their workday? This is what we're talking about. And if that isn't clear after we talk to you, that's a problem, because you should be able to leave these conversations and be able to say, hey, I think that there might be a risk here, right? I think we need to ask some questions about what's going on. So we also try to include a lot of examples of what this looks like, depending on the sector, depending on the occupation. Because the way that you deal with job loss is very different than the way that you deal with algorithmic management. And I think in some ways, as trade unionists, we're a lot more equipped. We kind of get job loss. We've been dealing with that in many different incarnations through contracting out or whatever for a long time. So we kind of get job loss, but I think it's algorithmic management, it's surveillance culture in the workplace that we don't always spot and we're not always as aware of. And then when we get in front of members, we hear their stories, and we hear about a long-term care workplace where they're pushing geolocation bracelets on workers, which track their every movement throughout the workday and provide performance management data to their employer. And their employer is saying, oh, this is for health and safety purposes, right? And we won't use it to discipline you. We promise. And you're like, oh, so this is happening. These are public sector workplaces that are some of the more protected areas of the labor market, right? We're not talking about the gig economy. These are public sector workers. We have workers that get pop-up screens, whenever they're inactive, and they have to click the reason why they were inactive. We have workers whose task assignments are done through an app on their phone, and at this committee meeting, these hospital workers are like, oh yeah, workers are getting called into disciplinary meetings all the time because they are taking more time than is allocated in their algorithmic task manager app, right? Because probably they stopped to help someone. Maybe a patient needed some help or some support, or maybe their coworker said, hey, can I get your support for a moment? I need help. So it really can tear, I think, at relationships, and public services, right? Like in a hospital, right? If you have a worker who feels like they can't take the time to answer a question because they're going to get disciplined. So you start to hear these stories. You also start to hear about how many really awful staffing and pay systems that are being put in place right now that are messing with workers' lives and that are violating collective agreement rights, right? And that locals are having to file grievance after grievance after grievance because this technology does not, it does not work with 24/7 workplaces that operate 7 days a week, right? So I think the storytelling is also where we start to really see how this is impacting workers. And it's also, I think, how we build, the base of support and knowledge amongst members to take action. So the next key piece is collective bargaining. So that's where we as workers have the most control, right, over our work lives. So we've really been focusing on collective bargaining, and we have a bargaining guide, which again, people don't really, dig into unless they're really deep into and committed. But for those who are committed, this kind of outlines some of the ways that we can protect ourselves. And unfortunately, there's no one collective agreement provision that is going to prevent all of the harms that are possible in this digital age. And we have our traditional, we have established collective agreement language that is already there to help us, right? Our technological change language, some folks have monitoring and surveillance language. But we did feel like there were some gaps in terms of where we needed to build for this current era. So we have language on transparency and the right to information, impact assessments, limitations on high-risk systems, pulling from the EU Act, which is really handy there, and surveillance and monitoring. So yeah, we do call for emotion recognition systems, behavior manipulation tools, and biometric data collection to be banned within workplaces. And a lot of language about how workers' data can be collected and used. And we also encourage locals to be very careful when they're negotiating this language and to scope it broadly. We want language that lasts, right? Like we're still relying on our technological change language that was negotiated, 30, 40 years ago. We want language that will continue to apply in 30 to 40 years. We're also encouraging locals to enforce their collective agreements. Sometimes we haven't really relied on some of this language in a long time. And so folks aren't clocking, oh, the employer actually is supposed to provide us with notice when they're introducing technology, and they are not respecting the collective agreement. And we need to be making sure that they respect our current protections in the collective agreement, as well as pushing back on anything like, privacy invasions that would be unreasonable, like using the law, thinking about the human rights impacts, thinking about these algorithmic management systems and whether they're impacting equity deserving members in a different way than others, right? And then putting the case to push back against that. So we've got like our existing, tools in our belt, and then we're trying to add additional tools through expanded collective bargaining. But again, workers aren't going to take up these issues to the bargaining table unless they're knowledgeable first and about the issues, they care about the issues, they think they're really important. But also that they are mobilized and organized and willing to take action, because managers don't tend to want to give away management rights when it comes to technology. What we've heard when bargaining units have brought this language to the table is there is a lot of pushback, and employers are just saying, no, like we're not going there. So workers have to go in if they really want this language. They need to organize and they need to mobilize for that language. And you need to make sure that members understand why it's important. So again, like that's a lot of that education groundwork. And then there's laws and regulation. I might be going on. Am I going on and on? We do also need to push for laws and regulations that protect workers, that provide a floor for all workers as well. So we had Bill C-27, the Artificial Intelligence and Data Act, which died last year, which wasn't the most robust piece of legislation, but unions and allies were pushing to make it stronger. And we do continue to do work, with parliamentary committees and the consultation on the updated AI strategy, which I don't hold out too much hope for, but also to think about provinces, like where there's space to make movement on the laws and regulations that we need, right? And to map out where there's space, and even just to expand the language and the knowledge amongst our members and public policymakers about what we can do to address these issues and the harms, because honestly, I don't think most folks have given thought to how this technology can really undermine the dignity and autonomy of workers. And that maybe gets us back into the storytelling to make it clear, like what this can do to like workplaces and to human beings, right? So QP members passed a resolution at its convention last year to work with allies to lobby for laws and regulations that protect workers, public service users, and the environment from AI harms. So we are working on a backgrounder to lay out, and it's very much like to protect workers, because I feel like sometimes the needs and the rights of workers can get lost from the conversations around AI legislation. So we're really kind of drilling into what do workers need to protect them. So this conversation today has been very, very, very helpful in developing that position, as well as focusing on the broader social security network that we need.
Great.
So I will end
Great.
there.
Okay, excellent. Thank you all for wonderful interventions. I've been taking lots of notes. I got lots of questions. I'll pose a question to you, and then I'll let others, whether online or folks in the room who want to get to the microphones, I'll let you collect your thoughts, and then you go ahead and do that. I gave you a couple of early questions I was going to ask you. I'm gonna switch the order. I'm gonna go to the second question. I think it picks up from the conversation we're having. So employer interest in AI, I think, like any technology, is bolstered by the promise that it will deliver productivity gains and then by extension, more profit. In Canada, I'll say, you can back me up on this, one of the biggest grievances we hear on a macro level, whether it's from central bankers or bank economists, is our deplorable productivity record, especially when you compare it to other G7 nations. So of course now AI is the fix, right? AI is going to fix all of those problems. Governments are not only encouraging AI adoption among private sector employers, but implementing AI solutions to justify its own cost cutting of the public service. For workers, as I mentioned in my opening remarks, the challenge is how we claim our share of any productivity gains. For governments, how do productivity gains get redistributed to maximize benefit to society is the big question. No one has the secret sauce. No one's ever had the secret sauce, because it means we put a stranglehold on capitalism. That's effectively what we're doing. Instead of that, it's rising inequality, it's rising income disparity. So my question then to you folks, do you see this next iteration of new technology driven by AI, is it going to deliver different outcomes if we organize properly? Is this our last chance to get things right?
The big question.
Whoever wants to start.
I mean, maybe because I'm a long-winded academic, I'll try to be concise.
Now we got a lineup of people, so we're going to have to go quick now. So this is great.
But I did want to make a couple of points. And one of them is that I don't think AI technologies are actually that different from past technologies for most workers, right? So when I started studying AI in call centers, it looked a lot like the same thing I was studying in the early 2000s. So we are writing an article right now for another book from the ILO about call centers with co-authors in different countries, and we title it "Old Wine in New Bottles," right? Because basically, digital technologies, cheaper and faster telecom networks, mobile phones, internet, that was happening when I was doing my first research, and that was also used by employers to replace, control, and displace workers. Directory assistance workers lost their jobs. I mean, years after the switchboard operators had lost their jobs, digital monitoring became intense and constant. We were talking about that earlier, right? It many ways looks very similar. It's just a bit more, done in a different way under different conditions. And US and UK call center jobs were offshore. They were displaced to India and the Philippines. So this stuff is not new for unions, right? You've been dealing with this for a long time. I think there are 3 new challenges with generative AI. This is the 3. One of them is what Cory Doctorow refers to as enshittification, right? That AI can actually reduce productivity and quality while producing additional environmental costs. So I've been interviewing these game development workers, and they are told to use AI tools in their jobs, and their performance evaluations are based on this. But they described it as hanging a picture with a sledgehammer, like the older tools are often better and more efficient. And they also have all this extra work in correcting mistakes. So this is something we're going to ask in the survey, like how much time are they spending using the AI tools, learning to use the AI tools, and correcting the mistakes of the AI tools, and documenting their mistakes from the AI, or documenting why AI is not used. Somebody in an interview said, yeah, I just spent I had to document that how much time. So I spent 3 hours the past week documenting why this AI tool could not help me solve the problem more than another tool. So this kind of pressure to show the use and benefits, I think, is part of the bubble of AI, which is important to think about. The second is hollowing out of skills, right? Management thinks they need fewer entry-level workers. They're relying heavily on skilled workers to pick up the slack, but that's undermining the pipeline of skills to make the more effective use of AI tools. And also there's a kind of disconnect or a difficulty, I think, of management and understanding that those skilled workers came from somewhere and they're not being replaced, and they don't really have a plan for that. So one example, I think, of this kind of confusion about or difficulty in mapping out what the actual impacts are going to be is, again, from games. Heard an example about helmet design. Okay, so AI tools, you design a cool helmet, and then your AI tool can resize that helmet for all the other characters in the game. Well, game work, the game design area, they didn't like to have to resize the helmet. That was bad work. It was boring and annoying, right? So great, we have more time to do interesting work designing new quests that our customers, our gamers will love. And so they have an infinite appetite for this quest. But when I ask them, well, like, how many quests does the company think you need? At what point are they going to start cutting your jobs because you don't need that many more quests? And they sort of said, well, it's difficult for me to see that connection directly. So I think that's why it's hard to say this kind of skill augmenting versus skill replacing is tricky, and it has this long line. And then finally, I won't go into detail, but the generally declining quality of art, cultural products, media, services, education, that's something that doesn't show up so much in the productivity or the efficiency or the profits of the companies, but is quite important. So like in telecom and call centers, the example has been given already today about fighting with the AI chatbot and all the productivity losses to consumers from that. And in games, we heard a lot about this kind of feeling that the company was throwing AI at problems, and they were like, we're okay with 6-fingered zombie Santa Clauses, whereas the workers wanted them to be perfect and beautiful, and they wanted the art to really resonate. This was hurting their own feeling of love of their jobs. So.
Great. Who else wants to jump on that question? Anybody? Laura, yeah.
Just a few thoughts. This is not necessarily my expertise, but I do have a few things to say on this. So first of all, now we're in the era of AI agents, right? So we are being told that AI agents are going to do everything, replacing us in every possible task. They're going to do very sophisticated chains of tasks, bundles of tasks for us. So this will bring up even more problems in job displacement. But there is a way in which legislation can help in that regard, because as long as, for example, the AI Act mandates human oversight and explainability to humans, as long as these proposals are there and are enforced, there need to be people that actually are able to follow what AI agents are doing and explain why a certain outcome happened because of an AI agent. And also, if you actually speak to practitioners in companies using AI agents, I was in a panel on AI agents a couple of months ago when I was still in the US. And practitioners were telling, basically, we see internally that because of the use of these sophisticated agents that can go on the internet and do a certain amount of tasks from A to Z, basically, we need to hire more people to check compliance, because we don't know how much data they are processing that goes beyond what is legally possible. And if they are violating other laws, we have no idea. We need to track them. And so we need people. So imagine that. This is creating new jobs. And another thing I wanted to say is maybe Jenny can chime in on this, but I read recently an interesting research published in the Financial Times where it says basically that the job pyramid, you know, where you have a lot of entry-level jobs and then a few managers on top, because of this job displacement, and in particular at the entry level, is creating like a diamond shape pyramid instead of, so basically it starts small because you're not hiring people anymore. Then in the middle, you have a lot of people that you have already hired years ago, and then the managers. But this means if you don't hire people anymore because you think they are not useful anymore because the junior level jobs are replaced by AI, this research were warning in 15 years, your company will not exist anymore, because who will do your job? Like, say bye-bye to your company. You have also to think about this. So maybe indeed, I hear a lot, especially when I was in the US, the rhetoric now is prepare because this is inevitable, this job disruption is going to happen, so we won't need to work anymore. It's really radical what I've been hearing for a whole year, and for a European, I can tell you it's not necessarily pleasant, because nobody there is saying that this process can be governed and should be governed and accompanied not only by legislation, but also where legislation cannot go, which is policy action, policy tools, budgetary, measures to support entry-level workers. Janine was saying this already. The revolution, the AI impact can be governed. The displacement is gradual already, but it can be even accompanied even better. So I don't think we should just give in to accepting that this is inevitable. We won't need collective bargaining because nobody will be a worker anymore. So no, this is not what is going to happen.
I was going to say before we go, Sarah, I actually, I'm stunned. First time I've heard an employer making a short-term decision that actually ended up hurting them in the long run. Didn't know that was a thing. Anyways, I'm going to have to take some thoughts on that. But anyways, Sarah, and then we'll go to the questions from the floor.
Yeah, no, I think you raise a really important point. I think there is, a lot of talk these days that this is all inevitable and that regulation will not happen. And I mean, I think we can see what's going on with the political context, internationally and the role of the US right now, that like these are challenging times when it comes to regulation. But I think at least in Canada, we've got a population that does question what's going on and is concerned about whether this technology will benefit society and workers. So I think there's a real role for the left, for the labor movement to be raising these questions about how technology should benefit humans and it should benefit society as a whole, and it should benefit workers, right? We should be calling that question. And if it's not, then we need to be putting pressure. We know how to mobilize and put pressure on the folks who govern our workplaces, but also our like a political leadership. So I think there's a real role to ask those questions. But I also think it's important. I mean, I don't think at this point we know exactly what things are going to look like in terms of automation and job loss, but we certainly don't have the social security network that we need in Canada right now to deal with any job loss at all, right? Like our employment insurance system, a 55% wage replacement rate is not enough for people to work, to survive on. It's not enough for communities. So we need to be, putting pressure as well to improve our social security network so that people who are affected by technological change are supported.
All right, thanks for those answers. We'll go to questions from the floor. Go ahead.
Just playing into what just been talking here. Now that globalism has been declared dead, how would such a regulatory institution work? The AI companies and the data centers themselves are located in non-like-minded nations and regions. I mean, how do you use these AI agents when the data centers are in a hostile nation?
Yeah.
Not a joke. Because they're not located in the EU, not located.
Yeah, I know.
Yeah.
Absolutely. Anybody want to take a shot at that?
I mean, there's a reason sovereignty is coming up a lot more, but I think in Canada, we need to ask the question about what our government means by sovereignty and whether it meets our definition of sovereignty, you know, because I mean, they just gave money to Cohere to work with CoreWeave, a US company, to build a data center, right? So that isn't building up our own infrastructure. But I think there's a lot of larger questions about AI. I think the environmental consequences as well of generative AI, we need to tackle that. We need to address that. And we need to be asking, I don't know, there are multiple courses available as well with technology. There's also like, you know, purpose-built technology, you know, that can be developed as well. So I think, you know, as progressives, as a trade union movement, it's worthwhile having these conversations about what this means, because I think there's power, right? There's like, you know, like corporate power, political power in the US, and their vision of technology, you know, basically automating 50% of workers' jobs with no like social conversation about what that looks like. It certainly isn't, I think, any of our visions of the future.
Do you think any of these companies would apply an AI-based agent that was coming from North Korea with its data centers there?
Of course not.
I guess we asked the question, how are we using any AI going forward right now?
Well, in Europe, unfortunately, it's not so straightforward to consider the US an enemy yet. So, yes, we are growing more and more skeptical, but from there to completely cutting ties economically and technologically, it's a long shot, especially when Microsoft and OpenAI, etc., are still concluding contracts right now with the EU governments for cloud supply or other, or working directly with governments in providing AI systems.
Mm-hmm. Okay, cool. Okay. We got two more questions on the floor. Yeah, go ahead.
Hi, my name is Malcolm. I'm a graduate student at Osgoode Law School. So I have two questions, one specifically to Laura and second one, maybe any of the panelists could answer. So my question to Laura is, there is of course a race to regulate AI, which we've seen through the EU AI Act, but the AIDA as well in Canada, with a specifically risk-based approach to the AI Act. Instead of a human rights or participatory approach, which a lot of scholars have stated, the AI Act has received its fair share of plaudits and criticisms with a peculiar risk-based approach. This also seems to ostensibly have a Brussels effect example in Canada, which the AIDA was based on. To what extent then would the AI Act become a benchmark which might affect specific discussions regarding the directives, such as one on algorithmic management? My second question to Sarah and Virginia is, the erstwhile AIDA in Canada has been largely criticized as it was largely ignored has been heavily criticized. It has largely ignored the adoption of AI processes itself. Their submission.
Oh, I think the mic's done. You want to try this mic up here?
So QP in their submissions after the AIDA was after the AIDA came out, only after the draft of the AIDA was presented, noted that there is a lack of definition of high-risk systems and unacceptable risk categories, with workers having minimal say. There's also a false narrative that the AI minister, Evan Solomon, has noted AI would create high-quality jobs. So with workers and unions not having a meaningful say in the AI regulation, even after it was drafted, so how are unions using their institutional power resources to change this narrative, but mostly to participate in rulemaking besides using their associational and marketplace power resources? And how, if at all, are unions scaling their efforts, perhaps through coalition alliances with tech workers to understand technologies? Thank you.
Okay, who wants to start? You want to?
Okay, I'll start. If I understand correctly your question, you're asking whether the AI Act can serve as a benchmark for, yeah, okay.
No, my question is that the AI Act is based on a very risk-based approach instead of sort of a participatory one. And in fact, some of the scholars have stated that the AI Act has become sort of a ceiling instead of the floor, which might affect the directives, specific directives, such as directive on algorithmic management, which has been discussed. So to that extent, what is the sort of role being played and how that might be affected?
Maybe I should add some further context to what I was saying at the beginning. Thank you for the question, because it allows me to explain a bit better. During the whole negotiating process, we worked very closely with the Trade Union Confederation in Europe, the European-wide one, to make sure that we wouldn't cross that boundary to make the AI Act a ceiling. You know, that was exactly what we were trying to avoid. And in Article 2, you have a provision saying this is not the end of it. Both EU and member states still have the right to legislate further on workers' rights specifically. Especially because the EU AI Act is a regulation, so basically it's because the legal basis is product safety, single market, which is EU competence. So only the union can legislate on this in order to make sure that the single market is uniform. Products are the same circulating in the whole market. This is not the case for employment, for labor rights. Labor rights are shared competence between the EU and the member states. So there is only a certain level of coordination in the EU, but the member states also have the rights to set up the rules because they have their own cultures and historic relations, workers, collective bargaining, etc., etc. So basically, the only way you can approach labor law in the EU is through a directive. You cannot do it through the AI Act, which is a regulation directly applicable in the same way in every member state. A directive needs to be transposed by every member state, including the minimum level of provisions that are in the directive, and then adjusting to the national system. And member states have 2 years to do so. For example, the Platform Workers Directive is enforced, but member states have until the end of this year, so 2 years in total, to adapt into national legislation these provisions in order for it to apply. Now it doesn't really apply yet, whereas the AI Act applies in most parts, in some parts, but it doesn't depend on the action of member states at legislative level. So again, we really tried, and the role of trade unions was fundamental in providing us with data, with evidence of the abuses we heard about today. We were talking about these issues already, I don't know, in 2021, emotion recognition, biometric identification, monitoring of mouse clicks and the keystrokes, and without the workers knowing about it. And with them, we were always in constant dialogue to make sure we were not crossing that boundary. So I don't agree with this criticism, because this was exactly what we wanted to avoid. And without what we did, you would have zero now, because this directive, specific directive on AI at the workplace, right now, I don't see it happening anytime soon.
Sarah will respond to the second question, and then we'll take one final question, and we're already up for time, so we'll try to do this quickly, and then we'll adjourn. So go ahead, Sarah.
Yeah, for sure. No, I mean, I think you called the question. The development of ADA was very skewed. There wasn't consultation with unions, civil society, people, the public, the broader public, and it was just dropped, right? And then everyone was, responding to it. I think we see a similar tendency in the recent consultation where they, stacked the committee with a lot of corporate leaning folks with very corporate adoption leaning questions rather than looking at societal or workplace harms and risks. So I think there is work going on, building coalition structures to be able to take this on right now. And we need to do a lot more of that to be able to push back.
Thank you. Okay.
Sorry, can I add one thing?
Oh, yeah, quickly. Yeah.
Yeah, also to respond to this comment. What I meant when I said that we worked in constant dialogue with trade unions, I meant like us, me and my boss, my political group, and two more groups, which were the left and the Greens. But the rest of the parliament was not. There was no public involvement of trade unions or anything, because we were sensitive to this, and it was extremely important to us to include in the legislation. We took it on board and we made sure it stayed in the final text because we agreed on other stuff that we didn't like. We swallowed stuff, but so it was not structural. Yeah. So
yeah, a lot of similarities. John.
Thank you, first of all. And we've been talking about collective bargaining. My name's John Dagnolo. I'm the president of Local 200, and I also represent Auto on the National Executive Board for Unifor. I just received not too long ago, actually last Friday, some information. It has to do with humanoids. And I believe right now I'm talking to Angelo, who's a humanoid, because I don't have a slide deck in front of me, and I'm just funny. But what's important is
I'm the humanoid? Wait.
Yeah.
Okay, gotcha. I just make sure I'm following this question that you're asking.
But I received at one of my plants that they will be using 19 humanoids to replace 61 jobs. And the technology is now here. Okay. So my question would be, how do we go about that? Because the impact on factories, when you think about it, because this factory has approximately 1,800 people, and this is the first phase. And so I'm wondering how I can get around, what can we do? Because we always talk about in the language future technologies, but okay, what's that mean? So now we're in the position that it's here today. So what can we do to get around this? How are we going to fight? How are we going to argue this? Because this will devastate our industries.
It's an ominous question to end the day on. I don't know if any immediate thought, other than I'm going to say there's some really big guys that work in that auto plant. They could probably take those humanoids, rip their hearts out or whatever it is. Yeah, especially John. But any thoughts on that? Or I can also wrap it up. But
first of all, we start to hear that we should start treating AI agents as colleagues, that they should have HR as well. No, I'm sorry, no. Humanoids is a sugar-coated way to say just sophisticated AI agents something, but humanoids, no, they will never be. And let's see how it works out, because maybe in a factory context, automation is much more straightforward, as Janine was also hinting to this morning. But let's think of the case of Salesforce. Salesforce I remember the first panel I moderated as a senior fellow for CSIS was with a lot of big techs, and I had a lot of fun debunking their statements. And Salesforce was all about, oh, the era of AI agents. Oh my God, this is going to be a game changer. Just a couple of like a month ago, not more than a month ago, they just admitted publicly that this is not going to work. It's not good enough. It was they bet too high on it, and now they're rolling back. So what tells us that these humanoids aren't going to be replaced by humans anytime soon? I don't know.
It's a very practical takeaway of don't treat them like a human. So John was gonna go buy them coffee. It's probably a bad idea. We don't go for breaks with the humanoids. Yep. Any other final thoughts?
I mean, again, I just make the point that that I think Unifor has probably a lot of history and toolkit in dealing with automation of different forms, and so not treating this like something that is radically different or new, and just approaching it the way in which, past the battle then is now is like, call out these strategies for what they are. It's often a cynical attempt to use innovation technology as certain ways to escape commitments to workers and society, right? Absolutely. So some of these broader things that we've been talking about, making sure that that the employer is also getting attention for this, that there are broad solidaristic networks across the supply chains and across unions and groups of workers in other countries where the company might be using this as an opportunity to play with different groups of workers off each other, right? To decide where they're going to invest in the plant that maybe produces those robots and who's going to do that work. These are our old labor lessons that can continue to be relearned.
Yeah. And good structures in our agreements that we can use to leverage. Final thoughts?
Yeah, I'd say, we can also call the question politically too, like I think we are in a context, all the polling data says that the public is really concerned about this technology, and they're concerned exactly about that. They're concerned about being replaced by a robot. So I think, raising the profile of this, and as well, like we do need to kind of lift up, our entire system of supports, and we do need to have kind of like broader based campaigns amongst the labor movement and really call the question on these types of practices which are hurting workers and communities.
Very good. So to close this off, thank you all for these wonderful interventions, Laura, Virginia, Sarah. Round of applause again for our wonderful panelists. Thank you for sticking with it all the way to the end. We have now ended the day of programming for this. So again, just a couple final reminders, your headsets, please just leave them at your table. You will go to classroom E, which is where the reception is going to be. And you've now, because we've gone over time, you now have like 3 seconds to get out of this classroom or else bad things are going to start happening. Okay, thank you, everyone. Have a great evening.